Thank you for joining the Arc of Grays Harbor as we present our 2023 Guardianship and Other Alternatives virtual workshop. Welcome to the Arc of Grays Harbor's Guardianship and Other Alternatives workshop. We're so glad to have you here today as we explore the important topic of guardianship and the alternative options. My name is Christy Childs. I'm the Information Services Director for the Arc of Grays Harbor, and this workshop is part of our yearly workshop series titled A Full Life Ahead. The ARC is an organization dedicated to advocating for and supporting a better quality of life for people with intellectual and developmental disabilities. I am so excited to introduce you all to this evening's special guest speaker, Angela Carlson-Whitley. Angela is a partner at Carlson-Whitley Luther LLP in Tumwater, Washington. Angela's focused her legal practice on guardianship and conservatorship, court visitor work, and fiduciary representation for the past 13 years. She represents family members and professional guardians and conservators, as well as facilities and respondents. Thank you so much for being here with us today, Angela.
My pleasure. Okay. So I'm going to talk about guardianship and conservatorship tonight. And before I get started, just my disclaimer is that none of this is intended to be legal advice. So you're going to hear a lot about the law and procedure, but I'm not your attorney. I don't specifically represent you. So this is just going to be general information, not about anybody's specific situation. And if you see me sort of looking back and forth, it's because my laptop has the camera, but my big screen that doesn't have the camera has my presentation. So I'll be kind of looking back and forth. So what we're going to talk about tonight is, and let me go to my next slide here, changes in the guardianship law. So you may or may not know guardianship law changed recently. What is guardianship? What is conservatorship? What are less restrictive alternatives to guardianship and conservatorship, and what kinds of resources are available and out there that might be able to assist you in navigating through that process. So a few things, especially for those of you who may already have a little bit of a working knowledge of guardianship. Terminology has changed since January 2022 when the new statute took effect. So we used to just call it guardianship, and we had guardianship of person and we had guardianship of estate. And now we have guardianship, which is the care of the person, and we have conservatorship, which is the person who makes financial decisions. That may or may not be the same person. The respondent is the individual who might need a guardian or a conservator. We used to call them an alleged incapacitated person. Doesn't seem to matter what kind of terminology changes they make. They're always a mouthful. They don't think about that when they're coming up with these terms. An individual who is subject to guardianship or conservatorship is the person for whom a guardianship or a conservatorship has actually already been established. Court visitor is really just a fancy name for a court investigator. Their job is to investigate whether a guardianship or a conservatorship is actually needed, who's the right person to serve, and whether or not there are any less restrictive alternatives. And unless I say otherwise, I'm probably just going to say guardianship for most things because it's just easier and less unwieldy than saying guardianship and conservatorship every time I'm trying to mention guardianship. Letters of office are the guardian's authority to act. That's the piece of paper you need that says that you actually are the guardian and you do have the powers and authority of a guardian. An acceptance of office, we used to call that an oath. It's basically just your promise to do a good job as the guardian and that you're going to follow those statutory requirements for what your duties are and your obligations in managing this other person's life. All guardianships based on disability require a professional evaluation, which is prepared by a doctor during the process, and it takes a special court form with specific information. It's not just a progress report from the doctor that, you know, gee, I had my annual checkup, but I'm doing great. It requires certain types of information that are outlined in the statute. So a little bit of background in history. It was May of 2019 when the governor signed the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act into law. We call it the Uniform Guardianship Act, or the UGA for short. We used to have Revised Code of Washington. So Revised Code of Washington are our state statutes. And we used to find the guardianship sections under 1188 and 1192. Both of those were repealed as of January 1, 2022. So they literally threw out the entire statutes and they came up with this new statute. And that is now found in RCW 11.130. And you can just do a Google search, RCW 11.130. You can pull up the statute and look at it yourself. Great idea just to kind of scan through and I say scan, it's like 200 pages, it's pretty long. But a lot of the sections have, names or headers that'll kind of tell you a little bit about what's in it, so you can sort of look to certain things that might interest you the most. The statutes in Washington, regardless of whether you're talking about 1188 or 1192 or the new 11.130, we have always had a mandate to look at less restrictive alternatives and to only do a guardianship as a last resort. Under the new statute, it's a little more difficult to establish a guardianship in that now the way the statute reads is that the court absolutely cannot establish a guardianship if there are any appropriate, available, less restrictive alternatives. And when you're looking at those, it's not just, it doesn't have to be the perfect solution. It has to be adequate. So just because something might happen to your child is not necessarily going to be the basis for forming a guardianship or a conservatorship unless you've tried some of those other things first and they haven't worked. So we'll talk a little bit more about that as we go. There is a new less restrictive alternative available under the new statute called supported decision making. So we will be talking about that. And there's also something called an other protective arrangement that can be used in some limited circumstances in lieu of a guardianship. And it doesn't last forever. It's just meant to get kind of one maybe discrete task accomplished. So what is guardianship? What is conservatorship? Well, guardianship or conservatorship is essentially just a legal relationship created through the court where one person is entrusted with the care of the person or the property or both of someone else. You are literally stepping into someone else's shoes and helping them with all of their life decisions. In order for that to happen, the court has to deem that person to have met the requirements of the statute that they actually need a guardianship or a conservatorship, and that there are no less restrictive alternatives that either are in place or that can be put in place and that are appropriate. Guardians, conservators, they're considered what we call fiduciaries. Fiduciary is just a fancy name for somebody who is held to the highest standard of trust. Your job as a fiduciary is to act only in the individual's best interest or as they would want. You cannot act for your own benefit. You can't do things that you maybe could be a little loosey-goosey when you're managing your own affairs. You can't do that when you're a guardian or a conservator for somebody else. You really have to follow the rules and keep things on the up and up. When might a guardianship be needed? So assuming that you've sort of done the analysis and there aren't any less restrictive alternatives that are appropriate or that can meet the individual's needs, typically we look at establishing a guardianship when a developmentally disabled child turns 18, which is probably why most of you are here. But we also have other situations that you may run into in the course of your life when a guardianship might be necessary. You might have a parent who develops dementia and they didn't do powers of attorney in advance, and then it's too late and you end up needing a guardianship in order to manage their affairs. Or somebody might have a traumatic brain injury or some other kind of cognitive impairment that happened later in their life. We also have situations where we sometimes do a guardianship for somebody who is mentally ill, although that's not always the best solution in those types of cases. Again, like I said, guardianships are a last resort. The great thing about them, though, is they can be very flexible. You can do a limited guardianship. You can do a full guardianship. The idea is to provide just that level of support that the person needs without unnecessarily taking away their rights. So if they only need help in a few areas, you might perhaps be able to do a very limited guardianship just to give support in those areas, assuming, again, there are no less restrictive alternatives that can be utilized. There are a lot of alternatives to consider before you jump to a guardianship. One of the most common, I'm just going to kind of give you the list and then we'll actually talk about each of them. But the one that most people think of first is durable powers of attorney for healthcare or finances. We also have something called a mental health advance directive, which can be helpful when you have somebody who does have a mental illness. Supported decision-making, which is that new thing that we said is now available under the statute. The informed consent statute, which is a specific Washington statute for medical decision-making. Representative payee-ship for Social Security benefits. There's a similar program called the VA fiduciary program for individuals who get VA benefits. We have something called ABLE accounts that allow you to save money for someone who's disabled without affecting their public benefits. Special needs trusts, which is another vehicle for doing the same thing. And then joint tenant bank accounts, although we don't always recommend those. It just kind of depends on the circumstances. If you do end up needing a guardianship for whatever reason or a conservatorship, there is a mandatory online training that you have to take in Washington in order to be a guardian or a conservator. Doesn't cost anything, it's free. It's pretty easy to find online. You can just do a Google search for Washington online guardian training and it'll be the first thing that pops up. But there's a Washington Courts website that has all kinds of resources on it. And one of those is the Guardian portal, and that's where the training can be found. Okay, so what standard is it that the court applies to guardianship? When would they decide that a guardianship was appropriate? It's a very high standard to establish a guardianship. It's clear and convincing evidence. That's the absolute highest standard you can have in any kind of a civil case. So very difficult to prove. In order to establish a guardianship, whoever's filing the case, the petitioner, would have to prove that the respondent lacks the ability to meet essential requirements for physical health, safety, or self-care because they are unable to receive and evaluate information or make or communicate decisions even with appropriate supportive services, technological assistance, or supported decision-making. So that's prong one. But on top of that, you also have to have the appointment has to be necessary to prevent a significant risk of harm to health, safety, or self-care, and there are no less restrictive alternatives. So you have to show all of those things in order to establish a guardianship. In order to establish a conservatorship, it's pretty similar. The difference is they have to be unable to manage property or financial affairs for the same reason, limitation in their ability to receive and evaluate information or make or communicate decisions. And the appointment is necessary to avoid harm to them or a significant dissipation of their property, or you need that conservatorship in order to access or obtain funds or other property needed for their support, care, health, education, welfare, or somebody that's entitled to their support. And again, that there are no less restrictive alternatives available. So again, the court cannot establish a guardianship or a conservatorship if there are appropriate less restrictive alternatives. So informed consent statute, durable powers of attorney, mental health advance directives. You do not need to write any of this down because I'll give the PowerPoint to Christy after the fact and she can send it out to whoever wants it. Mental health advance directives, rep payee-ship, VA fiduciary, ABLE accounts, trusts, and joint tenant bank accounts. So the informed consent statute doesn't require anybody to do anything. It's just an available statute that you can use if you need to be able to make a medical decision for your child and they're over 18 and they have a disability and they cannot make a decision on their own. So the statute can be found under 7.70.065, and essentially it creates a hierarchy in the statute of individuals who can make decisions for someone else who can't make their own decisions. It starts with a guardian. If there's no guardian, it's an agent under a power of attorney. If there's no agent, then it's a spouse. If there's no spouse, they look to adult children. If there are no adult children, then they look at parents. So for those of you who have an over 18 adult who can't make decisions, they're not married, they don't have kids, it would be you as the parents who can make that decision for them. If you're no longer around, adult siblings would also be able to make that decision for them. They also did recently add on to the statute to allow individuals who are not directly related to make decisions for another person. provided that they have some sort of close relationship with them. So they know enough to know what their medical decisions would be if they were competent to make them. And that individual would have to sign an affidavit to that effect in order to be able to act. This statute does not work well if there's more than one person on the same level, because they have to agree. So if you have, for example, divorced parents, and one parent says they need this surgery and the other parent says, no, they don't, we can manage this with medication, you're going to have a problem, because the doctor is not going to know who to look to make that decision. So it doesn't work in that kind of a situation. It does work if everybody is in agreement. The other time it maybe doesn't work is that doctors, just because this statute is available, doesn't mean the doctor necessarily has to honor it. So if you've got a kid who is saying, no way, you're not giving me that shot, I hate needles, unless the doctor is willing to say, okay, clearly the child doesn't understand, mom, dad, I'm gonna let you make this decision. They might say, hey, he's giving me a valid reason for why he doesn't want this shot. So just because you say he needs to have it, I'm sorry, he's telling me no, so I can't give him the shot. So that could be another situation where you might run into trouble if you're just trying to use the informed consent statute to make medical decisions. Representative payee-ship is for money, specifically Social Security benefits. It does not apply to any other kind of money, not wages, not gifts, just Social Security benefits. It is essentially Social Security program to allow someone to manage the benefits of somebody else if they can't manage their own. So think of it as Social Security's power of attorney, because Social Security doesn't honor powers of attorney, nor do they necessarily honor guardianships. If they are a federal agency, they do not have to follow state law. So they have their own program. You have to apply. If they decide that your child meets the criteria, then they will name you as the representative payee. You will be responsible for managing your child's Social Security benefits, and depending on the circumstances, you will report to the Social Security Administration on how those funds are spent. Generally speaking, if you are the guardian and the parent and your child lives with you, you don't have to report to Social Security. If your child lives in an adult family home or supported living, or you're not the guardian, then you will have to report annually on how those funds are spent. Having said that, it's a really easy report. It's basically, I spent this much on food and shelter and this much on everything else. So pretty bare bones. The VA fiduciary is a very similar program through the Department of Veterans Affairs. If you have an individual who's receiving veterans benefits, you can apply to be their VA fiduciary. Same thing, it only applies to VA benefits. They don't have any exceptions for reporting. You always have to report to the VA, and you will have to report to the penny on how those funds are spent for the individual's benefit. Durable powers of attorney is probably the most common alternative that most people are at least aware of, even if they're not entirely sure maybe how they work or how do you get one. They are essentially, it's a contract that allows the individual who's signing it, they're called the principal, to name someone else so that they trust, they're called the agent, to manage either their healthcare or their finances or both. You have to be over 18 to execute a power of attorney, and you have to have legal capacity to sign the documents. And when I say legal capacity, by that I mean you have to understand what you're signing and what you're authorizing your agent to do on your behalf. And that's pretty important, because I know most people kind of think, well, I need to have a will. The will is the most important thing to have. But if you think about it, the will doesn't take effect until you die. Who cares what happens to your property after you die? You're not going to be around to see it, right? But with a power of attorney, somebody can really mess up your life if they want to. So if you choose the wrong person to trust, they can create a whole lot of trouble for you. So that's a big deal, and you do want to make sure that whether you're signing one for yourself or your child is naming somebody, that it's somebody who really truly is trustworthy, and that you're not just picking Uncle Joe because he's Uncle Joe. You know, does Uncle Joe actually know how to manage money, or does he have a gambling problem? You know, does Aunt Char panic and maybe faint every time she goes to the doctor's office, you know, or the hospital. So maybe she's not the right person to make medical decisions. So kind of think about those things when you're looking at doing powers of attorney. But really the biggest thing is that the individual has to know what they're signing. The other problem with a power of attorney, which is not necessarily a problem, but it can be a problem, is that typically the adult children who have capacity to sign one are also those most likely to get themselves into trouble with a power of attorney. And I don't mean necessarily, they're not getting themselves in trouble with the power of attorney. They can go out and get themselves into trouble, and you can't override their decision-making with a power of attorney. With a power of attorney, they are sharing their authority with you. They are giving you permission to help them. That doesn't mean they can't go out and buy a Ferrari on their own or sign up for that really expensive cell phone with all the little, you know, tricks and gadgets and the unlimited whatever. You can't stop them from doing that with a power of attorney. If it's a conservatorship and they've lost the right to contract, they literally contractually do not have the right to sign those documents, so the contract would be void. With a power of attorney, you would have to go argue with the company and explain to them, look, they're disabled, they don't understand what they signed, please can you just let us out of this contract? And maybe they will and maybe they won't. So that's one of the issues that can be problematic with powers of attorney, just again, depending on the situation. So these are the kinds of things that if you go and meet with an attorney, they're going to be able to go through that analysis with you based on your individual circumstances and your child's individual circumstances. ABLE accounts. So ABLE stands for Achieving a Better Life Experience. They were specifically authorized not even all that long ago. It took a long time for the legislation to be passed that authorized ABLE accounts. And the idea was that we have this large population of individuals who are receiving public benefits. They can't have more than $2,000 in resources, which is, it doesn't give them any way to save for things like a vacation or expensive dental work that isn't covered by insurance, or therapies that they need that aren't covered by insurance, without getting kicked off their public benefits. So parents and other advocates were trying to come up with a way that money could be saved for this purpose, and not just in a trust, which typically requires a large chunk of money to make it worth it to do a trust. And it also allows individuals who are maybe physically disabled but not cognitively disabled to also save money and manage those funds on their own. So that was the purpose of ABLE accounts. Because of the way that they are structured, they're based on a 529 education plan. So it's actually an IRS regulation that creates them. And each state has their own program with their own custodian for the entire state. So it's not like you can walk into your local credit union or bank and say, I want to open an ABLE account. It doesn't work like that. So whoever the state's agent is, that is the losing the word, but the person who manages the program for them, you know, it might be Vanguard or Fidelity or BNY Mellon, one of those kind of big investment companies. They're the custodians for these accounts, and each state has their own custodian and their own program. You do not necessarily have to participate in Washington's plan. There are other states that allow non-residents to participate in their plans. And so that lets you shop around when you're trying to open an ABLE account. There's a really fabulous website that's listed at the end of my materials for the ABLE National Resource Center, where you can compare up to 3 states side by side and look at the differences in fees. Some of them are, you know, you can have maybe a checking account or a savings account or a combination of a checking account and an investment account. So there are different options, different fees, different custodians. So definitely do your research if you're going to open an ABLE account and sort of pick and choose what is going to work the best for you. Things to know about the ABLE accounts are you can't have more than one account. You can't have more than $100,000 in any one account without losing your Medicaid medical. And you can't deposit more than $17,000 a year in an ABLE account. That amount changes periodically. It's tied to the federal gift tax exclusion rate. So again, it's that IRS thing. The other thing to know is that there are taxes and penalties if you don't spend the money correctly. Having said that, it's pretty broad in terms of category for what you can spend on. It's basically any disability related expense. So as long as you're not spending money on yourself or taking the whole family out to dinner and paying for it out of the ABLE account, you know, you want to keep it just for the individual who is the beneficiary of the account, then you're probably going to be okay in terms of your spending. The other nice thing about ABLE accounts is that you can spend money from the ABLE account for food and shelter, which you cannot do for a special needs trust. So that is one of the biggest differences between the ABLE accounts and the special needs trusts. The other thing to know about ABLE accounts is that there is a Medicaid payback. So if your child has been receiving services, and it's not necessarily medical, or it's typically not medical, it tends to be things like long-term care, residing in an adult family home, for example. Medicaid keeps track of that. They keep track of how much they're paying every month for your child's care if they're living in that kind of setting. And then at the end of their life, if they have an ABLE account and there's money left over in that account, the state gets paid back first, up to the amount that they've spent on Medicaid recoverable services. And then anything that's left, you get to decide where it goes, or you do that at the time you set up the account. You can name a remainder beneficiary, but there is a Medicaid payback with an ABLE account. Okay, so supported decision-making. This is that new thing that I was telling you about under the statute that we have not previously had in Washington. The idea is to help the individual make choices and to provide them with the support that they need to make those choices. So explaining risks and benefits, potential consequences of decisions, things to think about, all those things you already do as a parent, right? I'm sure most of you engage in supported decision-making on an informal basis already. This is just making it more formal and statutory. As far as the statute goes, it's an actual written agreement. Your job is to communicate with your child, encourage him or her to express their preferences, help them evaluate and understand the consequences of their decisions, and then help them carry out that decision. The difference, kind of the way I think about it with a power of attorney versus supported decision-making, is that with a power of attorney, you can take that piece of paper to the doctor and say, I need medical records, or I need to set up this appointment for this. Or you can go into the bank and say, I need a check for $100 to pay for this. And you can manage the account and you can do all these other financial things for them. And your child doesn't have to be with you. Supported decision-making, your child is still very much driving the bus. You are there to help them access information and make decisions and express to third parties what their decisions are, but you don't have a piece of paper that, you have a piece of paper, but you don't have a piece of paper that you can take to the doctor or the bank or other places and say, here, this is what I need to get done today. They're going to say, where's your child? So you would need to have them with you to help with that process. If you are the person being named in the document, you're called a supporter. Your child can have one supporter. They can have several supporters. It's whoever they trust to help them make those decisions. Any person, whether it's your child or any of the supporters, can, well, I should say, your child can terminate the agreement at any time. You can resign as a supporter at any time. And like a power of attorney, they can always act independently of the agreement. So just because they have this agreement with you doesn't mean that they can't go off and make their own decisions, just as they would be able to do with, even if they have a power of attorney. It has to be in writing, has to be dated, signed. It's a voluntary agreement, meaning nobody should be unduly influencing them to sign something or coercing them to sign something. And you have to have at least 2 witnesses over the age 18, or it has to be executed in front of a notary, and they have to notarize the document with their stamp. Witnesses can't be the supporters themselves, so you can't be a supporter and also sign as a witness. They can't be an employee or an agent of the supporter. They can't be anyone who's providing paid care to the adult. And they also can't be somebody who doesn't have a sufficient understanding of what the individual's means of communication are, such that they can interpret what they're saying or communicating or expressing. There is a specific form in the statute that's followed for a supported decision-making agreement, and it has to substantially follow that form. So you can, again, pull up that RCW 11130 and look it up. The form is right there in the statute. Capacity is sort of an issue with supported decision-making, in part just because it's so new. Some attorneys and others are of the opinion that the standard for decision-making to execute one is lower than it is for a power of attorney. Others think that it's equal to a power of attorney. Regardless, if your child tends to be easily influenced, this might not be the best option for them. The other thing to say about supported decision-making is that there is nothing in the statute that forces a third party to honor that document. So if you were to have your child do one and you went together to the doctor and said you wanted this information, but maybe the doctor said, well, your child's not really telling me this right now. I know you have this piece of paper, but I don't understand what they're saying. I can't really tell if that's really what they want. And then they say, no, sorry, I'm not going to honor this. There's nothing you can do under the statute to force them to honor it. That's not true with a power of attorney. With a power of attorney, there is an actual statutory process that you can go through to force somebody to honor that agreement. And then if they don't, and you have to take them to court to fight about it, you can get attorney's fees for having to go through that process. There are a few other new provisions in the statute, including emergency guardianship and conservatorship, which we did not previously have, something called an other protective arrangement. Decision-making standards are actually set forth in the statute, which they were not in the past. And we now have temporary substitute guardians or conservators under certain circumstances. The emergency guardianship and conservatorship process is not very easy. It's a very shortened, compressed timeline, and the standard in order to get one is so high that it's almost impossible in most cases. So it's not really being widely used. I think the legislators maybe thought that it would be very effective in certain cases, but it's really only working in situations, for example, where you have somebody in the hospital and it's a life or death situation and there's nobody to make it. You know, they're saying, I don't want my leg amputated, and the doctors are saying, but if we don't amputate your leg, you're gonna die. So it has to be something really, really serious before that's gonna actually work. Much more likely to just get a regular guardianship established as quickly as possible instead of going through an emergency proceeding. So an other protective arrangement is a new thing under the statute also. There are some specific examples in the statute, including medical treatments, maybe establishing someone on benefits, moving them to a specified location or placement, purchasing an annuity, collecting life insurance benefits, selling property, sort of very limited, discrete tasks that need to be done. And the idea is, instead of doing a guardianship, you get a court order that says you have authority to do this. And then once that thing is done, then it just goes away. There isn't any ongoing anything. The order will terminate and there's no guardianship, just you've done what you needed to do, and then you just get to move on. The other protective arrangements, the downside of them is that you still have to go through the entire process that you would go through to get a guardianship established. It's just that when you're done, instead of having a guardianship order saying you're now the guardian and or conservator, unless and until the court terminates it, you just get a one-off court order, you do what needs to be done, and that's it. It does solve some problems in certain types of cases. And then it avoids that ongoing relationship that you have to have with the court if you do need a guardianship or a conservatorship. And it allows parties to kind of think outside the box and come up with creative solutions to things, like using it maybe to modify an existing power of attorney that had something wrong with it. It maybe didn't include some specific authority that you needed, and you can add that to the document through the court order and then not have to do a guardianship. So it can be effective in some situations, not so much in others. The temporary substitute guardian conservator is really for situations where you have somebody who's maybe not doing an adequate job as a guardian and they potentially need to be removed. And so somebody has filed maybe a guardianship complaint with the court or asked the court to remove someone, and they need someone on a temporary basis until they can find a new person who will ongoing be the new guardian or conservator. So technically it's only up to 6 months that would happen. You can also use it if they're temporarily unavailable. So maybe the guardian had to have surgery and things didn't go as well as expected, and they're, convalescing and they're just not able to do their job for a period of time. Then they can ask to have somebody else appointed temporarily until they're kind of back on their feet. So decision-making standards, this is something I think that people have a lot of misconceptions about with guardianship. They think, well, if I'm the guardian, I make the decisions, right? And, I get to do what I think is in my child's best interest. Well, that's not actually the case. So when you are stepping into someone else's shoes and acting as a guardian or a conservator, your job is to do what they would do if they were able to make that decision on their own. If you have somebody who's elderly, for example, they have a lifetime history of making decisions in a certain way, and family likely know how they would decide in certain kinds of situations. And so your job would be to step in and do what they would have done and continue on as if they still could make their own decisions. It's a little more difficult if you have an adult child who has some cognitive deficits and maybe doesn't have the ability to fully understand the ramifications of more complex decisions. So then you still are going to try to talk to them about it. Again, that supported decision-making sort of standard where you are explaining to them the risks and benefits and trying to educate and teach them about how to make decisions and how to make good decisions. The difference is that unless the decision they were going to make is going to put them at significant risk of harm, you're supposed to let them do it, even if it's a bad decision. People are allowed to make bad decisions. People are allowed to fail, right? So that's one of the ways that we learn, is by making a bad decision and then suffering from the consequences. So again, if it's not going to put them at significant risk of harm, then you help them make that decision, and then hopefully they learn from that, and maybe it changes how they would make the decision the next time around. If they absolutely cannot make a decision and you cannot determine what their wishes would be, for example, you have a child who is nonverbal and has no other means to express their wishes, they don't have a communications device, or they can't use it with any accuracy, or they are so severely disabled that they have the cognition of an infant, well, then you're going to make decisions based on their best interest. But generally speaking, you're going to try to make the decision the adult would make, and only if you can't figure out what that would be, then you would be making the decision based on what's in their best interest. The other thing that we have a misconception about is that you as guardian can place somebody in a specific living situation over their objection. That is not true. That has never been true in Washington. There was a provision in the statute that would have allowed that with a court process, but it was taken out of the statute before it was enacted. So you don't get to say to your elderly parent who maybe has behavioral issues and needs to be in memory care that they have to go to memory care. You don't get to force them to do that. Same thing with your adult child, although maybe it's less likely that you'd be in that situation where you'd be forcing them. But in general, you cannot place somebody over their will, against their will, over their objection, into any kind of residential facility type placement. And if they do have to go to memory care, then you have to do certain things under the statute in order to make that happen. Either you have to get authority in advance, it's part of your plan, or you have to give notice in advance so that they have the ability to object if they want to. Another big one that people don't necessarily understand is the right to associate. Individuals have the right to associate with whoever they want, and that Doesn't matter what the means are. We could be talking in person, by email, by phone, by, Facebook Messenger, whatever it is. Even individuals with a disability who maybe don't have the ability to discern the motives of others, unless that right has been restricted through a court process, they have the ability to make those decisions on their own and associate with whomever they choose. This became a big deal when, I don't know how many of you would have heard or were aware of the Casey Kasem guardianship when it was going on in Washington State. That was a big deal. It brought a lot of news attention to this issue, and it's not actually typically guardians who do this kind of thing. More often it's individuals who are agents under powers of attorney, and they're using it to isolate individuals from other family members for whatever reason. But it is a big deal. It's not something you can do, even with a guardianship in place, unless you have a specific court order authorizing it. So that could be the guardianship order. If you've shown enough of a basis, either at the outset of the case or through asking the court to modify the guardianship to show that the individual has been exploited or scammed or something bad has happened to them because they were speaking to or communicating with somebody that they shouldn't have been, then you can get an order in the guardianship that restricts that access. You can take temporary action to restrict access while you go to court and get a vulnerable adult protection order. That's another option. The hard part about that is that if the individual objects, it raises the standard of proof from a preponderance of the evidence, so more than 50%, up to that clear and convincing standard, the same standard that applies to a guardianship. The other problem with a vulnerable adult protection order is it's designed to be against one specific individual. That doesn't help you when your 18-year-old can be let off by anyone and they're not going to say no. And so you need to protect them from the whole wide world at large. Or, they access the internet regularly and they're vulnerable to being contacted by scammers, or they're being exploited by friends at school who say, oh, you can buy me that Coke. You're buying one for yourself. It's okay if you buy me one too. Your mom won't mind, whatever the situation is. So if you need a more broad restriction on accessing certain things, you have to do that through a guardianship. A vulnerable adult protection order is not going to help you in those situations. So process for guardianship. Let's say you've either on your own or you've met with an attorney and you've determined that a guardianship is the only thing that's going to meet your child's needs and that's what you're going to pursue. What is that going to look like? So whether you do it on your own or with an attorney, the process is going to be the same. A petition gets filed in your local superior court. So wherever you reside, whatever county you reside in, that's where you would file the petition. You, as the person who files it, are the petitioner. Your child would be the respondent. You will get a court visitor. Again, that's that investigator appointed who's going to investigate, okay, is this guardianship necessary? Should it be a limited guardianship? Are there less restrictive alternatives? Who is the appropriate person to serve in that capacity? If your child objects, they will get an attorney appointed for them. Your child may not even understand what they're saying, but if they express any objection or they say, well, no, I want to get married, and you're saying, I don't think you should have the right to marry. Well, then they're going to get an attorney who's going to be appointed to represent them. And that's because the court visitor's job is to make a recommendation to the court as to what is in their best interests. That may not be the same as what they want. So their attorney's job is to advocate for what they want, regardless of whether it's reasonable or makes any kind of sense to you as the petitioner, okay? So everybody has their role to play in a guardianship proceeding. And the idea is that we want to protect the individual's constitutional rights because it's a big deal. You are taking away somebody's constitutional rights. And so we just want to make sure that they have every opportunity to object and that we have all through the process made sure that they understand to the extent that they're able to what's going on. One of the things that you have to have, again, we sort of talked about this in the terminology part, is a professional evaluation. It has to be the respondent's choice of doctor if they're able to say who they want to do it. It doesn't matter what kind of doctor. It can be an MD, it can be a PA, it can be an ARNP, psychologist, psychiatrist. They just have to fill out that very specific court form that has to contain specific information. And it includes things like, what are their diagnoses? What is their, kind of medical background and history? What is their functional ability to manage money, to make medical decisions? What is their prognosis for improvement? What medications are they on? Do those affect their ability to understand this process? All of those kinds of things are what you would see in a professional evaluation. And that is just one piece of evidence that the court and the court investigator look at. They're going to look at the totality of the information as they go through the investigative process. So the court visitor is going to want to talk to your child. They're required to advise your child of their rights. They'll go through and explain the petition to them. If your child's nonverbal and not able to answer, doesn't matter. They're still going to go through that information with them, and then they're going to put in their report that the child wasn't able to respond or express any kind of a preference or say anything. If they're able to say something, they're going to try to gauge whether those responses are accurate or not by asking things different ways and making sure they don't just say yes to everything. So they're going to ask, phrase things in different ways so they can ascertain that. And then, of course, after they've met with your child, and they'll probably ask to meet with them alone, so be prepared for that, just so they make sure that the child isn't constantly looking to the parent to answer for them, and the parent isn't popping in and answering for them without giving the child the opportunity to answer. So they'll talk to them, but then they're going to talk to you, and they're going to get more of a sense about the accuracy of your child's responses when they met with the court visitor. They're probably also going to want to talk to some disinterested individuals who know your child well, like maybe a teacher or a caregiver if you have outside caregivers who come in. Sometimes the DEA caseworker, if they're already receiving benefits through the Developmental Disabilities Administration, they may want to talk to the case manager. If I'm a court visitor and I'm investigating, I'm going to ask if you have an IEP you can show me. If you have your person-centered service plan from DDA, I'm going to ask for that, because that's going to give me a really great overview of what your child's level and abilities are when it comes to making decisions. So that'll be kind of their process when they investigate, and then they have to do a written report for the court. They actually do 2 reports. One of them is going to be a very detailed report explaining, why was this petition filed? Are there less restrictive alternatives? What is this individual able to do? What is their ability to make and communicate decisions? And what are you recommending ultimately? So that'll be a very detailed report with an analysis behind the answers to those questions. And then they do a what we call a public version. So that's the private version. That one gets filed with the court under a seal so that only the parties to the case and the court itself get to see it. It's not available to the general public. Guardianships are otherwise open proceedings, which means that anybody can go in and look stuff up at the courthouse and they can view all of the documents. So something you want to think about when you're drafting a petition, especially if you're writing your own, if there's very personal information. Think about it, how you word things if you're writing a petition yourself. The public document is just a really brief summary that summarizes what your recommendations are and says who you talked to and what you're doing and what you looked at, what evidence documentation that you perused. Otherwise, that's it. It's just very brief. There are individuals who might be interested parties in your case who are not actual parties to the case, so maybe more extended relatives who might get a copy of the public report, but not a copy of the private sealed confidential document. So once the court visitor has finished their report and filed it with the court, they get 45 days to do that investigation from the date that they're notified that they were appointed. petitions for guardianship in general, by statute, are supposed to come to hearing in 60 days or less. There's an absolute cap on that, essentially. And some courts take the position that if it's not done in 60 days and you don't request an extension of time, or someone doesn't request an extension of time, if you're going to go beyond that 60 days, then the court loses jurisdiction to hear the case and they will dismiss it and you will have to start all over. So don't let that happen to you. If you're filing on your own, make sure that if it's not going to be done on time, that somebody's asking the court for more time. The other thing that has to be done is your child has to be served with those documents that you filed at the outset of the case, and that has to be done within 5 business days. And that is also a jurisdictional defect where the court can dismiss the petition unless you take steps to correct it. And that's probably one of the biggest mistakes that people make when they file on their own, is that they don't realize that they can get the court visitor appointed on the same day that they file the petition and the other documents that need to be filed. They think they have to set a hearing to appoint the court visitor. But by the time they've set a hearing and gotten a court visitor appointed, you're way past that 5-day deadline. And then you have to figure out how to fix it. So and all of this comes back to the whole idea that constitutional rights are at issue here. That's why we have such strict deadlines and rules when it comes to guardianship actions. So huge ramifications for the individuals. So once the court visitor files that report, then the parties get 15 days to review it, and then you have that scheduled hearing. And typically the court's either going to appoint a guardian or conservator, or they're going to dismiss the petition for whatever reason, or they're going to maybe find that a less restrictive alternative is available and you don't actually need a guardianship or a conservatorship. Very rarely they go to trial. That does happen. It's not common, and it typically happens in cases where the individual is either mentally ill or elderly. I don't know of any cases that I've heard of going to trial, at least in our local area, involving young people. The cases that involve young people that do go to trial tend to be involving divorced parents who are fighting over the child, and not so much the child themselves expressing an objection. Okay, so let's say you went through that whole process, you got appointed as the guardian or the conservator. Now what happens? So in order to actually have that authority to act, you have to get your letters. So great, you had your hearing, the court signed an order. You now have this court order, but you have to sign that acceptance. You have to have done your training. If your child happens to have money, I know, not likely, right? Unless they maybe won the lottery or inherited some money, but let's say they have some money. If they have some money, then you might actually have to have a bond or a blocked account. A bond is an insurance policy that protects that money from you running away with it and going to someplace nice and sunny and sandy, like that picture behind me. So that would protect against that, and you cannot get your letters of guardianship if a bond is required until you have that bond in hand. So you literally have to take the court order, take it to an insurance company, have them issue a bond, take that bond, file it with the court, and then the court will issue your letters of office. 99% of the time, that's not going to be your situation. You just need to sign your acceptance of office, take it into the court, file it, and then ask for letters to be issued. Letters of guardianship or conservatorship cost $5 a pop. You want to make sure that you get at least a couple copies, not just one. And you want to make sure that you don't give your $5 copies away. So if, DDA needs a copy, then, provide it to the caseworker, have them make a copy for DDA's records, and then have them give you your certified copy back so that you're not shelling out bucks all over the place, because every time you need a new one, it's $5. So those are your letters of office. Letters of office expire. They expire based on when your next report is due. And that's because when you establish a guardianship or a conservatorship, you don't get to just go on your merry way and do whatever you want. You actually have to come back to court periodically on a set schedule and report to the court and let the court know how your child is doing. And there's specific, again, information that you have to report on. There are court forms for that we'll talk about. But If your letters expire, you have lost your authority to act. It doesn't mean the guardianship is gone. It just means you don't at that moment have authority. So you want to be aware of what those deadlines are and what that expiration date is, and make sure you get into court before they expire. And if you can't get your report done on time, then ask for more time and ask for an extension of your letters. You can get new letters for a shorter period of time to give you that time to get back into court if need be. So within the first 90 days after you're appointed, you have to file a guardian's or a conservator's plan, or both. And depending on your situation and what's established, whether it's a conservatorship or not, you might have to file an inventory and a budget. After that 90 days is up, so one of the changes in the statute was that now we have to actually have a hearing to approve the plan and the inventory. I used to routinely waive those. We can't do that anymore. So now you file your plan within the first 90 days, and then you have to set a hearing to have it approved by the court. So the court has to have an opportunity to review it. You get an order approving it. Your child has to have an opportunity to review it. Under the new statute, your child is an automatic notice party. So it doesn't matter that you're the guardian and you're stepping into their shoes and you're acting on their behalf. They still have the right to know what's going on in their guardianship, and anything you file with the court, you have to provide copies to them. So you will always be mailing or having somebody hand them copies of paperwork so that they know what's going on in their case. Again, to the extent that they're able to understand that. And even if they don't, you still follow the rules and give it to them anyway, and then make sure that the court knows you did that so that you don't have any issues with notice. So the court will presumably approve your plan. And then after that, you go back at the 1-year anniversary. Typically, in Grace Harbor, they will sometimes give you a 3-year reporting period from the outset. I don't recommend that necessarily. I think it's good to go back at the 1-year anniversary so that you get an idea of what the reporting looks like, what kinds of things you need to keep track of, and have that experience of doing it once rather than not reporting ever. And then all of a sudden, 3 years later, you have to go into court and report, and you're clueless on what it is you're supposed to report on, and you haven't been keeping track for the last 3 years. And I think it makes it much more difficult and much more likely that you're going to miss that deadline and your letters are going to expire. And then you're going to get a nasty letter from the court calling you in to explain why you haven't reported and your letters are expired. So even if they authorize a 3-year reporting period, unless you're represented by an attorney, I would encourage you to go back at the 1-year anniversary just so you get that experience of knowing what the court expects, what kinds of forms you're going to have to file, and go through that process. Okay, so that's kind of the general process. Once you have done your first report, then you're going to be set up on a regular, typically it'll be a 3-year reporting cycle. Depending on your county, if you do file late, the court may bump you back to annual reports until they're sure that you're able to get your reports in on time. Otherwise, as long as you are reporting as you're supposed to, then you'll just be on a 3-year reporting schedule. You'll just go back every 3 years. Every 3 years, you'll give the court an update, and then you will get new letters. And you will be on that schedule for as long as that guardianship is needed or your child is alive. Guardianships are not static. They can change. You can ask for them to change. So you establish a guardianship when your child's 18 because they really needed it at that point in time. And then over the next few years, they gain some skills, they get a job, they are living in supported living in an apartment with only a few hours a day of help. Maybe they don't need that guardianship at that level anymore. Maybe they're able to make more decisions on their own, and you can go into court and say, you know what, my kid can drive now. I want them to have their right to drive. I want them to be able to vote. I think they can make their own medical decisions, except when it's super complex stuff. And then I want to be able to help them if that happens. You can tailor it to whatever your child needs. So you can always go back to the court and say, I don't think we need this at this level anymore. And if you know exactly what you want, you can ask for that. And if you're just not really sure, you can always ask the court to appoint a new court visitor. and do a new investigation and make some recommendations about what is the appropriate level at this point in time for your child, in terms of what rights might be able to be restored to them. And that is one of the best things, my favorite things about this job is when we get somebody who can graduate out of guardianship, because they've gained so many skills that they're able to manage on their own, or with, just a little bit of informal assistance. So that is kind of the overview. Changes in the law and guardianship. There are lots of great resources out there. Washington Law Help is a fabulous website. If you're not aware of it, I highly recommend you get on there and just kind of look around and see what they have to offer. They do have form power of attorney documents. They do have a form supported decision-making agreement. They do have explanations of what guardianship is, and what powers of attorney are, and what Medicaid is, and what kinds of things does it cover. So they just have a lot of great information about these different areas of law. The ABLE National Resource Center website is that one that I mentioned that has that 3-state comparison tool, so you can look up ABLE account features, fees, custodians for up to 3 states side by side. So you're looking at them all right next to each other, and you can see what those different options are if you want to open an ABLE account. The Washington Endowment Trust Fund is a pooled trust. We didn't really talk about trusts. I don't know if I just skipped that slide or if I took that slide out. I don't typically recommend revocable living trusts. And when I say revocable living trust, I mean a trust that you're establishing now during your and your child's lifetime from your money, and that you can terminate if you choose to, and that it's meant to be there as a pot of money for your child's special needs, things that public benefits doesn't cover. So that's what a special needs trust is. It is a pot of money that doesn't affect your child's public benefits and allows you to spend for things that they wouldn't otherwise be able to afford, or they would lose their public benefits. So to keep them on their benefits, you can establish a special needs trust. Special needs trusts get very complicated very quickly, depending on the source of the funds for the trust and how it's being established. So Arc of Washington is typically the one that we recommend the most frequently, the Washington Endowment Trust Fund, which is run by Arc of Washington. They serve as the trustee. So when you have a trust, you have a beneficiary. That would be your child, the person who's being benefited by the funds in the trust. And then you have a trustee, who is the person who manages those funds. For the Endowment Trust Fund, it is Arc of Washington who is the trustee. And that's because it's a special kind of trust called a pooled trust, where all of the funds of all of the individuals who have accounts with them are pooled together for investment purposes. Doesn't mean that your child doesn't still have their own account and they know at all times exactly how much money your child has in their trust. It just allows them to get a better return on their investment when they have a large amount of funds in order to invest. The Endowment Trust Fund, you can set up trust using your money or your child's money. We don't mix funds in a special needs trust that come from those two different sources. So if you as the parent have a big chunk of change that you want to set aside for your child's future, then you can do it through the Washington Endowment Trust Fund. It'll cost you $600 to set up an account, $75 a year. They have matching funds, which makes it pretty easy. And then you don't have to deal with the headache of managing that money. They take care of all of that, and you want money, you just ask for it. Has to be for their supplemental needs, and they will determine whether or not what you're asking for meets that criteria. But assuming it does, they're going to either pay the third party directly or cut a check to reimburse you for that new mattress that you bought, or whatever the situation might be. The benefit when you're doing it out of your own money comes back to that, what we talked about with ABLE accounts. There is no Medicaid payback if you create a special needs trust with your money for your child's benefit, because it's your money. You are setting aside your money, and you can do whatever you want with your money, right? If you are going to set up a trust with your child's money, let's say your child works and you have a really hard time keeping them under that $2,000 resource limit, and you decided an ABLE account wasn't right for you because you didn't want to have to handle that money. You'd rather have somebody else handling it. So if you were going to put their money in a special needs trust, the policy is, the Medicaid policy is, we're not going to let somebody put their own money into a trust just so they can qualify for public benefits. That wouldn't be fair, right? But if you're a disabled individual who is on public benefits, we'll let you put aside your money for a period of time and use it for your supplemental needs, things that you wouldn't otherwise be able to afford. But if something happens to you and you pass away and there's money left in that trust, we get paid back first. So they're essentially loaning you back that money in a way. That's the purpose of the Medicaid payback. So the endowment trust fund, you can open up a trust for your child with your money. That's called a third-party trust. Or you can open up a trust with your child's money. That's called a first-party trust. Two completely separate agreements that you would sign with them. You don't mix them. You wouldn't put your money in a first-party trust. You wouldn't put your child's money in a third-party trust. Can't do that. So two different trusts to accomplish two different things. You could also, if you had that pot of money, you could pay an attorney $3,000 to draft a trust for you that you would then be the trustee of and manage during your child's lifetime, or you could have somebody else manage the money for them. Whoever is the trustee, you would want to make sure that they understand what it is they can and cannot spend money on, because when it comes to special needs trusts, the rules are very strict, not necessarily easy to follow if you're a layperson and don't really understand. And you can get yourself into a lot of trouble and get your child kicked off their public benefits if you don't understand what you can spend that money on and you don't spend it appropriately. Because DSHS does eligibility reviews and they'll look at your statements and they'll make you provide documentation of things. And if you were not using those funds strictly for your child's benefit, or if you were spending them on things like rent, you could, again, get yourself into a lot of trouble and end up with your child getting kicked off public benefits. So that's why we don't delve too much into the whole trust thing unless we're talking about the Washington Endowment Trust Fund, because then you have a professional who's managing it, who can make sure that the funds are being appropriately spent and it's not going to affect your child's public benefits. So that was a short and probably confusing primer. And if anybody has questions, you can chat. And Christy can tell us what those questions are, and I'm happy to elaborate. For the Washington Endowment Trust Fund, your child has to be a client of DDA to qualify for that trust. The alternative, if they don't, maybe they're higher functioning, and at this point in time, their IQ is too high and they don't qualify, they would still qualify for the Lifetime Advocacy Plus pooled trust. Same concept, different trust manager is all. And it's not limited to just DDA clients. Anybody can do a trust through Lifetime Advocacy Plus. And then, of course, I know you all know about South Sound Parent to Parent and all the great things that they do. So there's some information about them as well. If you are looking for legal assistance to establish a guardianship, there are a few different options. Yes, you can do it yourself. Yes, it is complicated. Yes, you might do it incorrectly and then need to fix it. But maybe not. Some people do just fine. Others find it a real struggle. The one option, if you're low income, is Thurston County Volunteer Legal Services. They do have attorneys who can provide advice. So for example, they could go through that initial analysis with you about whether guardianship might be appropriate or whether there are less restrictive alternatives. They do not provide full representation. So you would still be responsible for going to court on your own, filing documents on your own, doing all of the legwork essentially, drafting the documents. They'll look at your documents. They can, advise you on making changes to the documents, but they don't draft them for you. They don't file them for you. They don't represent you at hearings. They are just there to provide advice. The Washington State Bar Association has a moderate means program. Technically, I think it's really mostly for family law, but I have had occasional calls from them for individuals whose household income is between 200 and 400% of the federal poverty level. And basically, in those kinds of cases, the attorneys will just offer a sliding scale based on your income. They may want to see a copy of your tax return to verify your income in order to determine what that level would be. And then it will just depend on what their hourly rate is, because a reduction of 50% and your hourly rate is 300 is very different from your hourly rate is 225. So every attorney charges different rates. So it just depends. You can certainly call around. It's not always a matter though of how much the attorney charges, as it is a matter of how efficient they are and how well they know their area of law. Because the better they know it, the more experienced they are, they tend to be more efficient. And even if they maybe have a slightly higher hourly rate, unless it's a big firm where they're maybe charging for everybody along the way, typically your rates can still be as low or lower than if you found somebody who was less expensive that maybe dabbles in guardianship. You don't want a dabbler. I can't tell you how many times I've seen that go wrong. I know I mentioned one of those situations where cases got dismissed for lack of jurisdiction, and I've seen that happen a couple times where I've had people come to me because their attorney had gotten them all the way through the process to the final hearing, and then the case was dismissed because they never served the person who needed a guardian. They didn't do that service within 5 days, and then it was too late because they'd already gone through the whole process. And then trying to get your money back from an attorney that you paid a $3,000 advance fee deposit to, and then you have to turn around and pay another attorney to do it all again for you. Definitely, do your homework, get, references from other people, other friends of yours who've maybe gone through the process with an attorney that they liked, that they thought did a good job. Ask around, call around. Word of mouth is probably the best way to find an attorney. And you want to make sure that you're comfortable with them and that you feel like you're being listened to and that you get along. I mean, you want to work with an attorney that you enjoy working with. You don't want to be having a miserable experience where you feel like your attorney's never calling you back and you never have any idea what's going on in your case, but you just keep getting these bills. I've been on the other end of that, so I know what that's like. So pick somebody that you like and that you get along with. And don't be offended if you meet with somebody and they say, I don't think this is going to work for us. I don't feel like we're compatible. Then you just move on and find somebody who is. I can tell you that kind of the going rate for attorneys in the area is somewhere between $200 and $300 an hour. I think the average is about $250 for most of the attorneys that I know. And some who've been in practice a little longer maybe charge a little more. Honestly, I don't even know anybody at this point who charges only $200. I don't know anybody that charges less than $225, but that doesn't mean you would necessarily be able to find somebody if they're maybe newer to the practice. Court forms. So you can find court forms online. The best website is courts.law.gov. They have all of the state court forms on that website. So that's the largest number of forms available. They come in PDF, they come in Word, and it doesn't cost anything. You can just download them. Most county superior courts do sell packets. So you can go in and say, I need to establish an adult guardianship, and they'll sell you a packet that'll get you through the beginning part of that process for 25 bucks or whatever. And then when you need to go back and do your annual reporting, they'll have a different packet for that process. I guess the benefit to that is it might include instructions for your local county. It might not. The Washington Court's website does not include instructions because every county does things differently, and the best source of information for that is going to be your county's website or talking to your county superior court clerk about what those processes are. And then some superior court websites actually have their own local county forms. Maybe not for everything, but maybe for some things, and some things you maybe have to use their forms for depending on the county that you're in. Some of them have literally like mandatory forms. So if you don't use our forms, you get kicked back.
Thank you for joining us for today's presentation. If you have any questions, please reach out to the ARC at 360-537-7000.